Hello, good morning, and welcome to today's webinar, Top 10 Ways to Prevent Employee Lawsuits, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Michelle Wilcox, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you're using a tablet, you may need to tap the screen for the options bar to appear. Then you can select appropriate option. We may not respond immediately, but we will work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we'll be online afterwards to respond or may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenters will be answering questions at the end. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan website. In addition, we offer mandatory preventing harassment training in English 3 times a year. With that, let's begin today's webinar, Top 10 Ways to Prevent Employee Loss. Today's interactive session will be facilitated by CJ Westrick. CJ Westrick, SPHR, has been in human resources management for over 25 years and has worked in companies with 25 to 1,750 employees nationwide. CJ received her SPHR, which stands for Senior Professional in Human Resources, national certification in 2002 and has a bachelor's degree in business management. She started HR Jungle in 2006 and targets companies who want senior-level HR expertise on a part-time basis. HR Jungle provides business owners and management teams workable solutions and hands-on assistance with employees and legal compliance throughout outsourced HR services. So I'm going to turn it over to you, CJ.
Okay. Just a second while I get my screen up, everyone. All right. Are you able to see the full presentation?
Yes. It's not in presentation mode, though.
Oh. It is on one of my screens. Hold on a second. Let me turn that one off and maybe it'll come back to this one. Oh, I can see it in the background there. Hold on. All right. Now is it?
Yep. Looks great.
All right. Ah, great. Hello, everyone, and thank you for joining us. And today we're talking about the top ways that you can avoid lawsuits. And California is a lawsuit crazy state alone, but there's other states that have a lot of laws coming in place now too. It's coming to the point to where I think California's not going to be the only state, people complain about. But we're going to be looking at what you have in writing, what some of the government's hot buttons are, and practices that you can use to help avoid claims. So I always like to kind of start these things with a little bit of stuff that's been in the news. United Airlines, they paid over $321,000 plus attorney fees because one of their captains posted explicit images of a flight attendant to multiple websites. Without her consent, they named her even so that people could find her. And when the EEOC did this lawsuit, they also required that the company then go back and do Title VII protection notices to all employees and to revise their policies to include both on and off-duty internet behavior. One of the things I've seen is EEOC, the Equal Employment Opportunity Commission, they focus a lot on different harassment stuff. you know, the sexual harassment, the retaliation, all this kind of stuff. And what I have noticed is when they do file claims or go into court for a company, they are often asking the courts to approve additional, it's not just the money anymore. They're wanting the company to change behaviors. And so I've seen EEOC push a lot of other things in there as part of the decision that comes out. We've got Supercuts. They paid $2 million as for settlement based on allegations that managers weren't being reimbursed for work done using personal cell phones and vehicles. If a company requires a personal property being used, the company should pay for what they call the convenience. The company didn't have to provide the vehicle, or they didn't have to provide the phones. I know this was a big thing a couple of years ago in a lawsuit in California where we first started having to pay for using an employee's personal cell phone instead of providing them with a company phone. So you can see some of the areas that are getting, you know, touchy or touchier than they once were. Walmart has paid $5.2 million in damages to an employee, a 16-year-old employee's or 16-year employee's status. I can't even talk this morning, so sorry about that. But they terminated an employee who had been working there for 16 years. He had a disability, and he worked as a cart pusher, and he'd been doing this just fine for the 16 years. But when a new manager came in, the manager required him to submit new medical documentation to continue the accommodation, and then ultimately fired him. You can see that that wasn't necessarily a wise move because it cost Walmart over $5 million for this employee. And oops, and it looks like I have the Supercuts twice, so we'll ignore that one. But we're going to just jump right in with our first polling question, Michelle.
Okay, so does your company have an employee handbook? If yes, has it been updated in the past 2 years? The answers are yes, but it has been updated in the last 2 years. Yes, but hasn't been updated in over 2 years. Or no, we do not have one. And we're waiting for the voting to get in. It looks like 66% said yes, and it has been updated in the last 2 years. 27% said yes, but it hasn't been updated, and 7% said that they don't have one.
Okay. And I mean, an employee handbook isn't legally required. And, you know, the one thing to keep in mind is if you do have one, you do need to keep it updated. You really should review it annually. It may not require any changes, but it's worth looking at because sometimes there's changes to your company policies that you want to be able to update. Other times there might be some legal changes that need to be mentioned in there. You know, I'm in California, so that's why I kind of use California as a reference sometimes for things. But both federal law and California law has been changing a lot over the last few years. So if you aren't keeping your handbook updated, that can be used against you. And the attorneys I talk with often say that you either need to have a good handbook, which means you needed to have it created by a professional, or you should just not have one. But that's harder to do these days, is to not have one, because there are policies and laws coming out now that they are saying must have the policy in writing. So you can give the employees this like a little array of written policies, but at that point, why wouldn't you want to just put them together so you always know everybody's getting the same information? But it is important. I review handbooks a lot, and it's amazing what people come up with. They have taken, you know, and kind of done this hodgepodge of pieces they found on the internet or that they pulled from prior employers and stuff like that. And not only is the flow of the handbook really bad often, usually, to where you're like going back and forth. I'll be reviewing one and it's like, wait, I know I saw this somewhere else. And I find that they've kind of taken one policy and broken it into two parts, completely different areas of the handbook. And so it really does pay to have a professional do it, and then to make sure that it is legally compliant, because it needs to fit what the local laws are for your location, like your city, as well as the state and then the federal laws. So there's a lot of different things. I've seen a lot of, I get email updates from law firms and stuff like that, and they I'm surprised at how many other states are starting to pull in laws similar to what we have in California, and hopefully they do them better, but it's not as widespread out there anymore that only California has laws that you have to think about. In California, we have location-specific laws, but I've also seen that in other states. There's, we've got like over 29 localities with different sick leave laws in California. But I'm seeing like Washington State, out on the East Coast, there's different things that I'm seeing that are popping up in New York City. Boston, is known for having a lot of laws also. So there's a lot of different pieces out there you need to keep track of, and that's why you want to not only stay updated on what's going on out there legally, but to make sure your handbook is representative of your company and those laws. And, nowadays there's a lot of states looking at harassment prevention. California required training, and not every state requires the training, but I think it's never a bad idea given the Me Too climate that was going on a couple of years ago and still is floating around out there. And then take a look at your company. What are the policies that aren't necessarily derived from some law, but talks about, everything from your benefits and what's the eligibility? Because when the Affordable Care Act came out, I've actually still seen some handbooks that have an illegal eligibility period. Affordable Care Act, which affected all states, said that insured, if an employee is taking your insurance, if you're offering it, that it has to kick in on like day 90 or day 91, they have to be covered. And so the old policies of saying, oh, after 6 months you'll be eligible, or after 90 days you'll be eligible, don't quite tell people what it is. Normally, the most you can have would be the first of the month after 60 days, because then you could be confident they would be insured by when they should be legally. So if you don't have it written correctly there, new people coming in and stuff like that won't understand it. Then we've got behaviors and processes. What kinds of behaviors are you trying to encourage or discourage in your company? To write some of those out. To talk about what happens when people go on leaves of absence. How does that affect their insurance? How does that affect their benefit accruals? I've even started putting in my handbooks to where when an employee goes out on a leave that's going to be more than a week, we want their company property back. Because I've seen when they're gone for a long period of time and then you ask for it back, they assume they've been terminated, and that's not the problem. The problem is you want to get stuff back so you're not having to rebuy all that equipment if you've got somebody filling in for them. So there's a lot of little things like that that your handbook should cover. And, they don't want to go into such detail to where now, it's like, well, you've got so much detail, but now you're missing this one little piece, so it may not be pertinent. It's general guidelines. So keep that in mind. It's always going to be general guidelines. It is not a day-to-day how to do something. And when you are making changes, if it's a big change, you want to make sure you're giving people sufficient notice. I've had clients, particularly given that this is January, a lot of them are changing some of their benefit plans. And, so we want to, give them at least, enough notice to decide what they're doing. The same as you do when you've got a new insurance plan coming in. You've got open enrollment the month before, so they've got a little time to hear the news and react to it. Jumping over to polling question number 2.
Okay, does your company provide training for your managers on HR policies and employment law? Yes, regularly. Option B is yes when we think of it, and the last one is no. We did get one question, CJ. It says if you review your handbook and no changes are made to it, do you change the date on the handbook?
No, because that means, if once you change it, you need to get everybody to sign off that they've received it again. And there's no point in doing that if you've had no reason to make a change.
That makes sense. Okay, it looks like we've got about 63% voted. 30% said yes regularly, 25% said yes when we think of it, and 45% said no.
Yeah, no seems to be the popular answer with a lot of my clients too. Some of it is because companies are working leaner these days. They don't have time, and a lot of times they don't have trainers available to know how to do it properly. And but keep in mind that your management team is what you're using to help build your defense about things going wrong in the company, whether it's because of knowing how your policies work, to knowing what the laws are, or knowing what their responsibilities are. In California's harassment training, in California, a supervisor can actually be individually sued for harassment, not just the company. And they need to know that. And they also are legally required to report any instance of potential harassment to senior management or whoever's responsible for taking on the investigations. And if you don't train your managers with that information, then you've got things that are going to go wrong in your company. One of the things I used to do when I worked inside was I actually had a weekly meeting with a certain level of managers. It was kind of the first line of managers that were actually working with the employees directly. And we had, everything from, I would sometimes just throw a question out there that they'd need to come up with the proper answer, but other times it would be talking about issues they'd seen and what is the correct process for it. And it worked really well because people learned what the rules were, remembered them because we were talking about them, on occasion, and it was only like a half hour to an hour meeting. But to talk about things like, it's like, oh, I approved a sick day because, somebody's pet needed to go to the vet. Well, that wasn't the reason sick leave was invented. It's usually meant for humans, not the pets and animals that the employees may have. So that's one of those things that, what is your policy? What do you want those managers to do in a situation like that? But it's what, the training is what makes sure that you've got a consistency and that everybody's doing it the right thing. If you've ever done performance reviews, you can see, I've seen them where they come back from managers and you can just tell, the difference, because some managers, I had a VP once that told me, well, as long as they show up every day, I think they deserve the highest rating. And it's like, okay, that's not quite the full performance review, but he would do that consistently. And we had to keep, reminding him that wasn't the whole review form. But you want to ensure compliance. You want to make sure everybody understands what the company wants managers to do about things. And if you're not talking with them about it, it's not happening. And if you're the HR person and doing this individually with HR people, with the managers, you're probably spending a lot more time on it than you need to because you're doing it one off every time instead of doing it as a group. Sorry, I had a cough there. So keep that in mind, that you need them to be aware of what's going on. I'm so sorry. And, California just passed a law about employees being able to file. Goodness, I've got a little sneeze fit going on here. Being able to file a lawsuit because they were denied the right to a leave that they should have been able to take. Now, most of the time when somebody wants a leave of absence, they're first talking to their manager. So if your manager isn't sure, when I've done manager training, the very first thing I tell them I want them to learn is to say, let me get back to you on that. Because if that manager isn't absolutely sure of the answer, they need to go talk to HR and find out what the right answer is. And because, people with management responsibilities carry weight in what they tell employees, in the sense that it will be taken more seriously the higher up that response is coming. But you want to make sure that you're doing some level of training. And some of it can be, you can bring in outside trainers if you need to, but sometimes it's just a matter of, a lot of times you might hire or promote somebody into a position and they're working off of what they've learned, not what they've been told your company wants them to do. So just because they learned how to be a manager somewhere else doesn't mean they know how to be the kind of manager your company would like them to be. Due diligence. Well, it's like when I first heard that phrase, it was being part of a merger or acquisition, because that's the big thing when acquisitions, the companies all have to do their due diligence to make sure that this is a proper deal. But in the employer stage, it is something you also need to do with your employees. You want to make sure, like with due diligence, particularly when you're hiring, what is, because there's a difference between what you can do after you've hired the person versus what you can do beforehand. And there are different laws that will say that, pre-employment drug screening, it's the background checks, things like that. Some of that has changed over the years. And I know in California particularly, we can't do a background check, well, we can't, until we've given a written offer of employment. And so, and the same thing with the drug screen. You can't do a drug screen until it's more, there's this timing to everything. So make sure you've got it down as to what your proper timing is for your location, because different states do different things. But then look at your interview process. Some people, I've seen some clients where the managers are doing all the interviewing and there's no thought process to whether or not they're asking the right questions, if they're asking legal questions. What's going on, with that. I just went through a nasty termination with a client because they didn't do their due diligence. Oh, this person had such a great resume, and and it's like, and he's worked in such great places and things like that. I just assumed. And, it turned out it was like, the employee you never ever want to hire. And had she bothered to really look at it, I mean, he had like a 1.5 year absence on his resume before coming to work for this client. And it's like, okay, why wouldn't you have questioned what that was about? And, and actually call some of the other companies he'd worked with. But you want to kind of figure out what is your due diligence in there. Background checks often are used by courts as a sign that you have done your due diligence when hiring, that you haven't hired somebody who was violent, because you actually did some due diligence to confirm you never got those kind of reports when checking their references, when checking with previous employers, things like that. But then to look, so what kind of tests are you doing during the interview process? Is it legal? I've seen so many times, particularly small companies, where they want to do what they're calling the how are they phrasing it? But they want to basically have them work for them for 1 or 2 days as part of the interview process. And it's like that just can't happen. That's paid time. You can't just pay them off the book payroll. If they don't work out, you terminate them. But there's things like that as part of your due diligence. If you're responsible for the HR component of your company, to take a look at that. And to look at one thing. I know I was at a legal update a couple months ago where they said you want to be careful when you're interviewing and asking questions and using whether or not they fit in your company, as opposed to, are their core values the similar as to what your companies are? And, and some of it's just phrasing, but it can be the cause or, defense of when you're having claims made. And to look at that when you are interviewing and they give you references, remember what that value is. If they're smart, they never put anybody on as a reference that isn't going to say wonderful things about them. So have you got questions you're asking those references that might pull out some other information that they weren't expecting? One of my favorites is to ask, if you absolutely had to pick one person, one thing that you would like to see this this person improve upon, what would that be? I've only had one person ever tell me they couldn't think of anything, but everybody else surprisingly comes up with these little nuggets that weren't part of the normal questions you might have asked. And it's like, okay, that's of interest. You take a look at some of this stuff, but kind of look and see what you're doing and whether or not it makes sense, whether or not it's legal. Okay, and third polling question, Michelle.
Okay, the third question is, are your pay stubs able to show a line item called penalty pay? Yes, no, or I don't know what that is.
All right, I'm guessing they didn't input my new my new questions, did they? Because that was, I changed that one. Well, because penalty pay is only in California. So what the question is trying to say is, are your pay stubs clearly showing the information legally required on a pay stub? And so the answers, I think, would still kind of fit.
Yeah, so 33% said yes, 16% said no, and 51% said they don't know what that is.
Yeah, see, that's because it's only California. So penalty pay is a California thing, and it's something we have to show as a separate line item because we're the only state that has very specific meal periods and rest break periods required by law. And if an employee misses it or doesn't take long enough meal break, stuff like that, we owe 1 hour penalty pay every day that happens. So that's why it's listed as that. But I took that off because this isn't a California only crowd. And but there are very specific rules of what, state and federal governments want to see on a pay stub. California's gotten a little bit pickier about being very specific about it. But, part of the rules is to ensure that your company's name is on there as it's still correct, I guess, is what I'm looking for, that it includes the employees, mailing information, that it includes, and it's easy to read. I think most of the complaints come because of it's not easy to read. I looked at a pay stub for a museum one time that I was helping audit, and it was the strangest thing because I'm looking at this and I'm having trouble understanding how they came up with the net pay, because they were putting things on there that didn't need to show up on a pay stub that were like their background calculations or for their system. And it's like, this is so weird. But in California, you want to be able to see exactly like what came out of it and how did they end up with the net pay. I think there's a lawsuit I was talking with an attorney about, that a $2 million lawsuit, that it turned out like 3 years ago or 4 years ago, somehow the company name lost a word in it, and the city dropped off on the whole block. Now, this is a company that's had the same name and same location for 40 years, but they ended up with a $2 million lawsuit because it wasn't on the pay stub as it was legally required to be. So this is why you want to take a look at something like that. But then we also want to be careful with money in general. Money is going to cause you problems every time if it's wrong. So you want to make sure that, your pay stubs / wage statements are correct. Wage and hour claims can often go back for years. So it's never quite, like the current issue that you really have to worry about. It's also all the history you've got going on there. Is your payroll calculating correctly? Are you paying for use of personal equipment that employees might be forced to use as part of their job? Are you paying non-exempts for their travel time? It's like commutes have never been compensable. It's like you don't pay for the mileage or for their time to come and leave, come to and to go home from work. But if they have to go somewhere during work, that is paid time and mileage. Are your paychecks always correct? The one thing I have found is that often you have your accounting department or even, outside service doing paychecks and things like that. And but mostly I find it when it's an inside accounting, department that's doing the payroll for you, processing it, and they don't take the money, a wrong paycheck as seriously as the employee does. And if it's not correct, you need to correct it right away. Even if it's to write them a manual check for the correct amount. You don't want that to drag on. There can be penalties for that. And it's a message. I've had employees tell me, it's like, obviously they don't care, that if they are putting that off. I've seen accounting departments do very strange things with paychecks, that they're thinking about how it's easiest for their system of when they do things, not for how it's affecting the employees. When I worked inside in one company, the accounting department ultimately was told they could not do anything. They basically weren't allowed to talk to the employees anymore, and they couldn't do anything unusual with the payroll unless it went through me. And this came from the fact that they decided right in December, we actually happened to have, it was just one of those fluke things. We had a new controller and a new accounting manager in the same year. So we had a fleet of cars because we had sales reps and they had the commissions and everything. And so they had this thing called fringe benefit, which was paying for the personal use of the company car. And in the past, what we had always done was just add that amount onto their W-2 and let them deal with the taxes, since they were usually playing around with all their taxes due to commissions. Well, this particular year, those two got together and decided to pull it off the final paycheck. So I got a call while I'm on vacation over the holidays from one of our regional sales managers saying, I just got a paycheck for $11 and I'd like to know why. Well, you can imagine my vacation did not go well after that. because I'm racing around trying to figure out what they did. And then it turns out, oh, not only did they do that, but now they've closed out the book, so they can't retract it. And it was a mess. It was a total mess, and affected our entire sales department, which was more than 50% of our employees. So we had 60 people out there at the time going, where's my money? So you want to be very careful with money. It's like, we just had minimum wages go up in a lot of states. Did you reflect that on the new pay stub, paychecks? Or were you waiting for some paperwork for it? When it's a legal change like a minimum wage and you've got people at minimum wages, you need to make the change. All right, number 4.
The next question is, do you know how to determine between an independent contractor and an employee? Yes or no? And looks like majority are saying yes. Yeah, we've got 90% said yes and 10% said no.
All right, I would maybe question that 90% because the rules are changing rapidly. In California, last year, in 2018, the California Supreme Court came down with a new ruling on how to determine who could qualify as an independent contractor. One thing to always keep in mind is that document, the independent contractor agreement, carries very little weight in court. You want it, but it don't depend on it. But California the California Supreme Court came up with this ABC test. Now, what was funny was we thought they came up with it at first, but oh no, it turns out that a version of that ABC test is in like 14 different states right now, and they actually kind of borrowed this from some state on the East Coast. So for once, it wasn't California coming down, with rules that made everybody cry. And but there is a difference. There's always been like 7 different governmental agencies with different rules for what qualifies as an independent contractor. IRS has a slightly different test than like California's. California's is more strict and more so nowadays. And so you want to kind of avoid misclassifications in general. So one is the employee versus independent contractor, which is very big in California right now because they have pretty much shut the door on most independent contractors in California. There are very few exceptions nowadays. Most people are having to become employees. So we've got that as a potential misclassification. And if you misclassify anyone, like exempt versus non-exempt, employee versus independent contractor, and that's not what they are. I mean, if they're an employee, yes. The only thing you can get away with is if you've classified somebody as a non-exempt employee, because that's as low as you can go, basically. If they're exempt, you have to be able to justify it. If they're an independent contractor, you have to be able to prove it. An exempt in California means the difference between having to pay for meals and overtime versus not. And if you don't have time cards, and suddenly you find out that exempt person doesn't qualify and is non-exempt, now you're looking at all of these missed meal periods that you've got no record of, whether or not it's overtime. In California, I've actually had to meet individually with 150 people with 4 years of calendars to say, why don't you mark on here every day you missed a meal break or you worked some overtime you don't think you got paid for? And the company wrote them a check to get that off the class action lawsuit they were dealing with. So looking at your classifications, I've seen a lot of companies always trying to fudge people into pumping them up to where they look like they're exempt. But frankly, they'll hardly ever make that meet the full test a lot of times. I mean, they really need to be, a true manager, someone who has responsibility for the hiring and firing, someone who, has true responsibilities, has authority to say this is what's going to happen, and it does. Not that they have to like go get approval all the time. And, and if you don't have people like that, California's made it kind of easy for that distinction, mostly because California has a calculation that says, nationwide, pretty much a minimum salary for an exempt person has often been 2 times minimum wage. In most other states, it's a fairly low minimum wage, so it's not anything to go with. Right now, California, because we've been trying to get our calculation is 2 times minimum wage times 2,080 hours, which is considered a full-time employee. So even if you've got an exempt person who only works 1 hour a month, they must make somewhere between 49,000 and 55,000, depending on the size of your company. It doesn't matter how few hours they work. There's a minimum amount they have to make from you in order to be exempt, period. So that 1 hour a month person still has to make, approximately 50,000. And that number is going up almost 5,000 a year lately because of changes to our minimum wage. Now, the federal government just put out new rulings for all the other states that says that, the new one, I don't remember the exact amount, but it's a little over 36,000. And that is actually a huge increase for the states that didn't have that before, because I think before the minimum in most states that didn't have specific state laws was somewhere between 21 and 22,000 a year, which is a very easy number to hit. Now at over 35, because it's trying to show you that the federal government is taking it more seriously on the level of person they feel should be exempt. So take a look at what's legal in your state and whether or not you're abiding by that. Go in and look at some of these positions. You can't go wrong with the non-exempt employee, but any other change in the status, you want to be able to back it up firmly, because at some point you could get tested on it, and being wrong is financially devastating a lot of times. Number 5 question.
The next question is, do you have a written sick leave policy that meets your local and/or state laws? Yes, no, or we have a PTO and don't need it. So somebody asked, how does the AB 5 changes the classification of independent contractors in California? CJ,
what it did was the AB 5, it came out a few months ago, provided some exceptions. So it kind of, and it's been like a lobbyist heyday in Sacramento, because it's like whoever has the best lobby wins. But what it did was it broke out certain classifications, like licensed professionals, CPAs, attorneys, doctors, people that need a license in order to do the work. That was one of the breakouts. And then a few other breakouts were like business to business agreements that, still had realm, but some of it is the old test that we used was called the Borello test. It had like a lot of different points. It had like 21 different points that the state would look at to see whether or not that could qualify as an independent contractor. The ABC brought it down to 3 points. So the AB 5 said, okay, other than this licensed group that we broke out as very specific, then we've got some other categories that we feel could be used the old test instead of this new harsher test. And so, but it's not a clean slate, because independent contractors truly have to look like a business. I mean, ideally, they have a business name, not just using the personal name. They've got a business license. They've got general liability insurance. They have marketing collateral. And really important, they have multiple clients where they're doing the same type of work. If you can't show that your independent contractors cover those bases, then you really need to go back and look at your independent contractors.
Thank you. Okay, so it looks like the poll has closed. 82% said yes, 5% said no, and 13% said that they have PTO and don't need it.
Okay, so the sick leave, I mean, as I mentioned, there's like over 29 different localities with different sick law versions in California. And like I'm in San Diego County, and so our county overall follows the state law, which is 24 hours of sick leave over the year. But the city of San Diego has one of its own laws, and that one requires 40. So I've got a lot of clients that have field employees, and those field employees go into San Diego a lot and do some work there. And so those companies have had to move up to the 40-hour level with, otherwise you've got this administrative nightmare of trying to track where your people are all the time. And then I've got another client who is a federal contractor there, so they've had to move their sick leave up to 56 hours because that's what federal contractors have to pay. So you really have to pay close attention to where your people are, excuse me, and what laws hit them, and to look at that, because I know there's a lot of states now adding the sick leave. The PTO combines sick leave, vacation, everything into one little bundle, but it still needs to meet the sick leave laws, which means you have to start accruing. Hold on. Sorry, I was on the phone like all day yesterday, and I think you're getting the results of that today. So PTO combines everything, but the sick leave laws, mean that you have to start it from date of hire. You can't wait until after 90 days to start their PTO accrual. It needs to show that you're not using those absences. How are they using it to meet the sick time laws versus other? The advantage is that it gives the employee multiple choices of how they use their time, and so you have less abuse of it for the sick leave. But the disadvantages are that the sick leave is often protected, so you have to be a lot more careful on those protections and making sure that your PTO policy covers that. I've actually got a lot of clients now where we're doing PTO for their full-time employees. We're doing a separate sick leave policy only for their part-time employees, things like that. So it's getting to be a lot more mix and match type of thing. But you want to see which of those laws you're subject to, and make sure that your PTO follows it, or make sure that you've got a written one. I actually had somebody tell me once that you can't, like in California, the state requires the 24 hours, or you can limit, I should put it the other way, you can limit use to 24 hours a year. But then I had someone tell me you can't actually hold them to the limit if they've accrued more than that, unless it's in a written policy. So keep that in mind, that you want to, and there's some states that are requiring a written policy now. So you really, it's becoming messier out there to do that kind of stuff. So also we have leaves of absence. These can be a nightmare on their own. Juggling act, California, we've got so many different kinds of leaves. It truly is a juggling act. We've got a chart up trying to help us understand when someone calls. I actually have this, I'm looking at this little wheel I get from one of the law firms that lets me help calculate it, because it's so messy in California. We've got so many different ones. But, there's different things that happen during leaves in every state. Some of it is that I see often where you get, we'll take pregnancy, maternity leave. They're out on maternity leave. You bring in an attempt to fill them in, and suddenly you've got what I call that drawer discovery, where you've opened a drawer and say, oh my gosh, they weren't doing nearly as good a job as we thought they were. They were just able to hide what they weren't doing. And suddenly I've got, the employers calling me. It's like, we really want to hold on to this temp. She's great. We don't want to bring back this other person. It's like, you know what? That's not an option. So, it's like, bottom line is they should have, been paying attention when the employee was working. But you have to be very careful if you terminate them on leave. Some leaves aren't, like a personal leave isn't legally protected. But I often will tell my clients that if I've approved, it's like if we approve a personal leave, I'm assuming you're holding that position open for them. But, it's like now if that leave gets extended, now we can talk about, okay, now we really do need to get someone in there. So it really determines on what kind of leave it is, what are the protections, and what are you doing there, and, because there's a lot of protected leaves and that you need to do something. One of the things that I was told by an attorney that I think is great, and I try and pass it on to everybody, is that if you're ever considering terminating an employee, it's even just this little dot in the back of your mind that you're worried about their performance or something's going on, and you're thinking this could be a problem later on. At the moment, that's that little kernel in the back of your brain, you email like your boss or HR that information. Just to say, I'm still keeping an eye on it. I haven't really thought about it at all yet, but, there's some problems with this employee. We may have to take some kind of action later on, because that puts a time block on it. It shows that if now this person, because employees have this really weird sense of knowing when they're going to get terminated, because I don't know how many, I swear it's like at least 30% of the companies that talk to me about wanting to terminate is like, we're going to do it this Friday. And then, it's like, oh, I get the call on Monday. Oh, we didn't do it on Friday because Sam, one of the people they wanted in the meeting, wasn't available, and they didn't do it still with the people who could make the meeting. And now on Monday, this employee has called in that they've hurt themselves. They've got a, workers' comp thing. They've got this or that that's protected. And now we're stuck. And it's like, so if you have situations like that, had you had that email that went out saying, I'm giving some thought, we might need to do something about this person, it shows that there were problems prior to the leave. Now, if that's the only thing that happens and it's 6 months later, it's not going to be very helpful. But if a lot of times it turns out that, they're just waiting to have that meeting to put the person on probation, and something happens that they delay it and this comes up. So they could still kind of put it in place the moment that person comes back. Or, there's things you can do, at least as long as you've done good documentation showing there's some thought process going on in the background here, and not waiting until you document at that moment. Number 6.
The next question is, how does your company know what to pay employees? Through salary and surveys, salary.com, etc., or we guess? And then somebody asked if in California, with regards to the 24-hour sick hours in a year, do you lose them the following year if you don't use them, CJ?
It depends on how you've set it up. We have 2 options. You can accrue, and if you accrue, you actually have to accrue 48 so that at the beginning of the new plan year, they've got that fresh 24 waiting for them. But if you front load the 24, then when the new plan year starts, you just reload it up to 24 or keep it at 24 if they didn't use any. But yeah, kind of like if they don't use it, it kind of disappears on them one way or the other.
Okay, it looks like only 54%, actually, we're up to 55% voted. 37% say salary surveys, 25% says salary.com, and 38% says we guess.
Guessing has become very popular. I mean, you know what the problem is, and I mean, it's when I used to work inside where I was in a pharmaceutical company, and we would, I mean, like 25 years ago, we were paying $1,200 to participate in this survey that really hit very close to home. I mean, it had geographic breakouts, so we could really say, for this city, here's what we should be paying. And so it was worth the money. But now I'm finding, some of the cost of those kinds of things are very expensive that most clients don't want to participate. They can't afford. Or, you've got other things, because stuff like the online, even in San Diego, there used to be a survey you would participate in just for San Diego County, and it didn't cover some of the higher level positions well, or technical positions necessarily, but it was great for like your warehouse, your admin, your accounting, all the G&A kind of things. But the last time I saw one of their surveys, which was about 3 years ago, it was sad to see so many positions now with no information in them. So it became less useful because a lot of people have gone online. The problem, as many of you may have found with salary.com, the ones that do that, is that the information is input, as opposed to a salary survey where the information is put in by HR, someone who understands what the positions are, knows what the ranges are, can put in accurate information. The online stuff that you can get for free, like salary.com, is input information from the employees, which, as I've seen over time, they have a tendency to think they're in a higher level position than they are because they don't understand the different levels. They pump it up and put extra money in there. It's like if you've ever had to confirm somebody's wage when they've moved to another company. And I used to always tell people, it's like, I will, it's like, if you give me a number, I can confirm whether or not that's what it was if the employee's given us permission. But I just preface it. It's like, but bottom line is it won't match because they probably included their bonuses, any commissions they might have gone. And that's not what I have to confirm. I'm confirming base salary. So the salary.com kind of stuff, unfortunately, is getting it from the employee, which is probably not going to be particularly accurate. And then you come to guessing. Sometimes your best bet is to have your HR department or hire someone outside, like an outside consultant, to go do a salary survey for you of your competitors. I've done that before. I've actually called around, it's like, here's the competitors. I've called around and I've told that company when I call their HR department, I will share whatever I find with you, and pull off the names, of course, of the companies, but, so that you can have, something to work with, because everybody's struggling with that. We have fair pay laws now, which I'd hoped when they started all coming in, both from federal and state laws, that you would see more of an uptake on salary options out there, but nothing changed. So now we're supposed to be trying to provide fair, numbers with nothing to work with. It's a dilemma, and you want to be able to back up the numbers you've got, because if you can't, somebody has a claim out there. Oops, I guess I could have shown you this whole thing when I slide. But, there are the laws. Let me see if I've missed anything. Oh, I know when these laws started getting passed, the attorneys in more than one legal update and personally would just tell me, it's like, frankly, the attorneys are the only one who will make money from these laws, because it will take time to process the claims. And in the end, the employee won't really walk away with much more than they had started with. But, and now we've got weird laws that make it even harder, because California's got a law that's been in place for a couple of years now, to where we can no longer, on applications or when hiring or even when using a recruiter, we can no longer ask an employee what they used to make. It's no, now you have a position, you decide what the value of that position is, and that's what you say the range is. That's the only information for money you're getting when you're hiring somebody. So it makes it more challenging, because you can't see, okay, what were they making elsewhere? And you don't know that anymore. But take a look at your pay structure, because again, money talks to employees. What are you doing? It's like, what is the hiring pay? What needs to happen for you to warrant a merit increase? Are you periodically going out there and trying in some fashion to see what the market value of positions are? I've had attorneys tell me that, where it's like, okay, we've got this position. It seems to be considerably higher price than what we're paying the 5 other people in that role. But it's like, I've even had where I've hired a consultant when I worked inside to go out and find out why a position was now costing us so much more. And it was just because there was that much demand for that particular position. And so the attorneys, well, I'm trying to argue, well, that's just kind of an out of the box situation of the moment. And he said, you know what, if that went in front of a court, it would show you're not paying the other employees enough money. You should raise everybody up to that new value. And I'm like, we're all gulping, kind of thinking that's just not financially possible. And so then that means you shouldn't be hiring somebody that's paid that much more than your other employees. It's a tricky thing, and employees are looking for that money. When you terminate cleanly. You don't procrastinate, because I see it start to go downhill so wrong. You start pulling responsibilities away from the person. It's like, I've had so many mishaps happening with clients because they knew they were going to terminate, and they charged off the starting block without even giving any thought to the effect of it all. Like, they start changing out passwords while the employee still doesn't know they're being terminated, or they lock the door of the, change the key to the office, or it's like they do these things instead of doing it in a well-mannered way. I don't think an employee should ever be fully, surprised when they're terminated. That there should have been ideally documents backing up that you've had conversations with this employee, or, they've been written up or something showing that it was coming this direction. And, and to be careful with that. You want to keep them short. Don't turn it into, a 3-hour termination meeting. I've found that the more you talk about what happened or what led to it, the more they think it's a negotiation and that they can save their job. So a lot of times you kind of have to just say it's a culmination of all these things, or I always say, come up with the cleanest, the simplest, most legal reason you can, and focus on that. It was a lot of other things, but this kind of took it over the top, and we just can't keep going forward like this. And that's it. Move on. And, because it doesn't really do the employee any benefit either by going through every little thing they've done wrong. That should have been done in the meetings before it got to this stage of where the problems were, what to do there. Attorneys usually tell me to avoid common use of severance packages. Because if you start using them, I had one client that started using them every time, and it's like, and now people were expecting it. And then they've gotten themselves into trouble because now if they, they should be used because you're trading their signature on a severance agreement for X amount of money. If you have no reason to think that you need them to sign off on not being able to come after you for something, then don't bother. It's you don't need a severance agreement to say, I'm going to pay you out for 2 weeks, but then that's it. We'll have you stop working now. We'll give you 2 weeks pay, and that's the end of it. If you feel that, it was all done properly and that they don't have something they could use against you, there's no need for the severance agreement. It is an exchange. It's not a common practice. And hopefully, you've got things clean enough to where it's more of a rare situation, not a daily situation. Our last polling question.
The last question is, do you have a resource for professional advice on employee issues? The answers are yes from my business attorney, yes from an HR professional or employment attorney, or no need yet. And then we did have one question we'll throw in here. If they have an on-call employee, do they need a clean termination? Was the question.
Yeah, you want to, at least at some point, you still want to end that relationship. So even if they're on call, I think if nothing else, it's like you want to let them know that you have no need of their services anymore. And, and it's like, because otherwise you're still kind of floating them on your payroll system, because you really don't want to terminate them in your payroll without having actually gone through the termination. I think it is just cleaner, because then they know they're free to look for a full-time job or whatever and don't have to consider you anymore. And you want to, I think, keep the relationship clean. It's like you hired them, you set up the rules of how this relationship would work, and now you're ending it. Whatever it is. I mean, it's not like it's a big drastic thing. It's just like, we don't have need of it anymore. We've brought that role in-house, or we found another, service to use, whatever. But, just to let you know, we're not going to be calling you anymore.
So it looks like the voting is in. 70% said yes from an HR professional or employment attorney. 19% said yes from a business attorney, and 11% said no need yet.
All right. So yay to those that are answered B, that got it from an HR professional or employment attorney. I find too often where I get news from a company where they've talked to an attorney, and like whatever the attorney told them just didn't work out well. And because particularly if you're in California, there are large law firms that only deal with employment law because it is big business there. So, and I know in some states where they don't have a lot of employment laws, it's not as big of a deal, and the company has a lot more rights or ability to do things that they want to do. But in the end, you still want to have somebody who knows those laws personally to help you with that advice. There's times, I have a whole company and employees with providing HR advice. But there are times when I'm going to, flip a company over, one of my clients, and it's like, you know what, I'm going to introduce you to this employment law attorney because we're at the line now where we need to see how it's playing out in court. We need to get another perspective to make sure I'm not missing something, because it's that important that you don't get a claim on this. Right now that thing is like independent contractors in California. It's like, we've taken it as far as we potentially can with our ideas of how to make it look like this is an independent contractor, but I want an attorney's viewpoint on it to see if we're just butting our heads against a wall or if he thinks it would fly in court. So, there's times that you need the right person. Business attorneys are specializing in setting up business entities, of dealing with business agreements. They will do some employment stuff, but that's not their specialty. So you really want to make sure that you're getting your advice when it's important and you're trying to avoid a lawsuit from the right person or company. All right, boy, right on time. Any other questions out there?
There's a couple that are kind of specific to their business that I'll go ahead and send on to you, CJ, after the webinar that we can address individually. But I'd like to thank everyone for attending today's webinar presented by Heffernan. We'll send you the information by email with instructions on how to access a copy of the presentation on our website. Thank you, CJ Westrick, for your time and expertise today. We hope all the attendees found today's webinar to be a valuable use of your time. Be sure to join us on February 11th for employment law updates. Thank you all and have a safe day.
Thank you. Take care.
Bye.